Welcome to the Dispute.a podcast. I'm Paul. Over the next 10 episodes, we're going to work through property disputes in the UAE, what they are, how they unfold, what your options are at each stage, and, just as importantly, when a dispute isn't worth fighting at all. This first episode sets the frame. We're going to talk about what pre-legal dispute resolution actually means, because the term gets used loosely, and the loose use hides the thing that matters most: the gap between a problem and a courtroom. Most people think about property disputes in two states. Either you have a problem or you're in court. The mental model is binary. Something goes wrong with your developer, your seller, or your landlord, and either you absorb it or you sue. That model is wrong, and the wrongness is expensive. Between the problem and the courtroom there is a wide space. In that space, most disputes are actually resolved. Pre-legal dispute resolution is the work that happens there. It's structured, it's deliberate. It's not just trying to sort it out. And it's where the realistic outcomes for most disputes are decided. When we say pre-legal, we mean before formal litigation is filed, not before lawyers are involved. Lawyers can be very involved in the pre-legal stage. Not before the law matters. The law is the backbone of every pre-legal position. Pre-legal simply means the dispute has not yet been handed to a court or tribunal for a binding decision. Why the pre-legal space exists? The pre-legal space exists because litigation is a poor first option for most disputes, and everyone involved knows it. Litigation is slow. A property case through the courts can take a year, often longer, before a binding outcome is reached. During that time, the issue itself, a delayed unit, a withheld deposit, or a contract you want out of, remains unresolved. Litigation is expensive. Court fees, legal fees, expert fees, and the cost of your own time can consume a meaningful portion of what you're trying to recover. Litigation is uncertain. Even a strong case can fail because of a procedural issue, an evidentiary gap, or a judicial interpretation you didn't predict. A courtroom is not a calculator. It does not produce guaranteed outcomes. Litigation is also damaging to relationships. If you are in a dispute with a developer you may deal with again in the future, the courtroom turns a disagreement into a war. For these reasons, parties often share an interest in resolving matters before they reach formal proceedings. Not always, but far more often than people assume. The pre-legal stage is where that shared interest is worked through. What pre-legal resolution is not. It is not informal complaining. Sending angry emails is not dispute resolution. The difference is structure, leverage, and a clear understanding of the legal position underneath. It is not giving up and calling it pragmatism. Some people label acceptance of a bad outcome as resolution, simply because pursuing the matter felt difficult. That is not resolution. It is not guaranteed settlement. Some disputes still proceed to court. Pre-legal resolution is the attempt to resolve before that stage, while remaining fully prepared to proceed formally if necessary. And it is not a substitute for understanding your legal position. If you do not know what the law says about your situation, you are not negotiating, you are guessing. The components of a real pre-la. The components of a real pre-legal position. A proper pre-legal strategy has 5 key components. First, an accurate understanding of the law. What does the legislation actually say about your position? Not what feels fair, what the law provides. Second, an honest assessment of the facts. What can actually be proven? What does the contract say? What documents support the position? Third, a realistic understanding of outcomes. If the dispute reached court, what are the likely results, and how probable is each? Any settlement should be measured against that reality. Fourth, leverage. What action can you take that the other side would prefer you not take? Filing with a regulator, escalating to a tribunal, or demonstrating credible litigation readiness can shift negotiations significantly. Fifth, a channel. Resolution happens through a process, negotiation, formal complaints, liaison with regulators, or structured communication between the parties. The channel matters because it determines who is listening and what pressure exists. The role of a liaison desk. This is where Dispute.a operates. A liaison desk sits between the party in dispute and the counterparty, managing the pre-legal process in a structured way. It assesses the law, reviews the evidence, builds a realistic strategy, identifies leverage, and handles the communication process toward resolution. The reason specialist support matters is simple. The counterparty is experienced. A developer's disputes team may have handled hundreds of disputes. An individual buyer is usually handling their first. That imbalance is exactly what a liaison process is designed to address. We'll discuss the mechanics of a liaison desk further in episode 3. For now, the important point is this: the pre-legal space is real. Most disputes are resolved there, and it can be handled professionally rather than emotionally or reactively. The mistake is treating the space between a problem and a courtroom as if it were empty. When pre-legal is the wrong choice. Pre-legal resolution is not always appropriate. Some disputes need immediate formal action, particularly where limitation periods are expiring. Urgent court orders are required, or the counterparty will only respond to formal proceedings. Some disputes are simply not worth pursuing at all. If the realistic recovery is smaller than the financial, emotional, and time cost of pursuing it, the rational decision may be to walk away. We'll dedicate a later episode to understanding when that is the right choice. A good dispute process tells you these things honestly. It tells you when pre-legal engagement is unlikely to succeed and when the dispute is not commercially sensible to pursue. A process that always recommends escalation, regardless of the merits, is not resolution, it is sales. What to take from this episode? Pre-legal dispute resolution is the structured work of resolving disputes before formal litigation begins. It exists in the wide space between a problem and a courtroom, and that is where most disputes are actually decided. A strong pre-legal position is built on 5 things: legal understanding, factual evidence, realistic outcomes, leverage, and process. A liaison desk manages that process professionally, correcting the imbalance between experienced counterparties and individuals facing disputes for the first time. And pre-legal resolution is not always the right path. Sometimes formal proceedings are necessary. Sometimes walking away is the better decision. An honest process tells you which situation you're in. In the next episode, we'll examine the boundary itself, when a dispute is still pre-legal, and when it has crossed into territory where only formal proceedings can resolve it. Thanks for listening. The full transcript is available at dispute.a. For pre-legal dispute support, dispute.a is where that work is done.